Nadia Bermudez of U.S. Law Network firm Kleindienst in San Diego, California. As we know, this has all been a very difficult time for the business community. They have had to make very difficult decisions regarding their workforce in order to stabilize their businesses. A legal counsel can help you make those decisions, and they can notice patterns that someone in-house might not notice. So for example, employers, by using an adverse impact analysis, can observe if there are patterns by which older workers might be more adversely impacted, or women, or people of color. So all of those things can be laid out in a candid discussion by way of a chart that's covered by the attorney-client privilege. I know that when I do this for my own clients, I also have a column for other types of things to look at. So for example, if the person is on a leave of absence, if they've filed for workers' comp recently, that kind of additional information can be crucial in making this analysis. Sometimes employers are tempted to use a reduction in force to address performance issues. While it may be very tempting to select out workers who have not been performing as expected, ultimately, if there is a claim that a reduction in force was discriminatory or wrongful in some way, we want to make sure that employers can justify their decisions about who is impacted by the reduction in force, and that if performance was at issue at all, that there is some record of disciplinary notes in the employee's file. Now that brings me to, how do you make these selections in a reduction in force? For those of us that are working in the private sector, we can rely on things like seniority, skill set, business needs, and other factors that make the decisions of whom to retain in a reduction in force more tied to the business needs themselves. Furloughs are now becoming a very common practice by employers. In some situations, and particularly in California, upon termination of an employee, final wages are due. Now, if a person is furloughed from their current position and there is no return to work date that's agreed to by the parties, it may be in effect a termination. And if it is a termination and a court decides that it was a termination, the final pay could have been impacted. And this could be a pretty steep penalty if there were dozens or hundreds of employees that failed to get their final pay. Those penalties can add up for the employer. As such, employers are highly advised to look at what the state rules are about final pay. And in the 50 states, the rules are all over the place. Florida and Georgia, by example, do not have any rules regarding final pay in connection with a termination of employment. Other states have varied rules, which might be tied to the next payroll or a certain number of days after a termination has occurred. The WARN Act obviously focuses on giving notice to employees, and in most cases up to 60 days, before a mass layoff occurs or a business closure. New York and California have their own WARN Act rules. And in both these cases, the state rules are much stricter for employers than the rules that are required under federal law. Here in California, the governor recently provided interim guidance regarding the WARN Act, and essentially has allowed the business exception rule now to be considered in the state of California, where it previously had not. In fact, the majority of states do not have what's known as baby WARN Acts. Finally, we are all hoping for a swift recovery post-pandemic. As employers bring back their employees from either a furlough or a reduction in force, it is important to make sure that these employees are brought back in a non-discriminatory fashion. As such, employers should consider the optics of rehiring and how that might be interpreted or received by individuals that were recently laid off or are currently in the process of reviewing their severance agreement. If you have any questions about the things I've talked about today, feel free to reach me at 619-239-8131 or on the firm's website at kleindienstlaw.com. Thank you.